All right, after the first week of the Kyle Rittenhouse trial, I believe this case was over. It was clearly self-defense. And really, after the second week, I thought the same thing, but then the defense made a huge mistake, and the prosecution, they got a shot. Check this out. My name is Nathan Laurie. If you are new here, we talk about the law and the facts. If you're about that life, don't forget to like this video, share this video, and subscribe to the channel. So here's my recap for the second week of the Kyle Rittenhouse trial. Now, for those of you who don't know who Kyle Rittenhouse is or what this trial is about, here's a quick clip.
Trial of a teenager who shot 3 people, killing 2 and injuring a 3rd during a riot in downtown Kenosha in 2020 got underway this week. Kyle Rittenhouse is charged with 6 counts, including first-degree intentional homicide and first-degree reckless homicide. Rittenhouse was 17 at the time of the shooting. He pleaded not guilty and is claiming self-defense.
So let me catch you up on what happened last week and where we are at in this trial. Now, we started this week off with the state continuing with its case in chief, presenting its evidence that they believe is going to show that defendant Kyle Rittenhouse is guilty of murder. Now, to accomplish that goal, they put on their star witness, Gaige Grosskreutz. Now, this is the man who was shot by Kyle Rittenhouse and lived to tell the tale. Now, this witness is critical to the prosecution's case against Rittenhouse. Now, the state claims that Rittenhouse was an active shooter who shot these men in essentially cold blood, and that he should spend the rest of his life in prison. The defense's theory of the case is that Rittenhouse acted in self-defense. Now, the defense wants to show that Rittenhouse was justified in shooting Grosskreutz. Specifically, the defense wants to show that Rittenhouse was justified in using deadly physical force to stop an imminent threat of deadly physical force or serious bodily injury to himself. And that imminent threat had to come from Grosskreutz. So the defense asked Gaige Grosskreutz this question, which was intended to prove that Gaige Grosskreutz was shot by Kyle Rittenhouse, and that shooting was justified. Here's the question, and here's the answer.
It wasn't until you pointed your gun at him, advanced on him, with your gun, now your hands down, pointed at him, that he fired, right?
Correct.
Bam!
Oh shit!
That's it.
That's
Over.
it.
Game over.
Directed
Over.
verdict.
Thanks for
Directed
playing.
verdict on all the murder charges.
Case dismissed.
Kyle knows.
Case
Case
dismissed.
dismissed.
Yeah.
Move for
Directed
directed
verdict on
verdict
the
right
murder
now.
charge.
Move for directed verdict.
He just exhaled.
What more do you need to
He
say?
looks like he's gonna cry.
That's
What the hell more do you
How
need
do
right
you
there.
not-
Boom.
How do
Admission
you
directed
not-
verdict.
How do
Good
you
night.
not acquit
Yeah.
after that?
And if I got this right, I mean, this is brilliant because this is a prosecution witness, and you have the jury has 2 choices here. They can say he's a complete liar.
Now, this testimony by Gaige Grosskreutz was so damning, even the left-wing propagandist news network known as TYT thought it was bad. Listen to what they said.
So on the shooting of Grosskreutz, he's going to have a very good self-defense case, right? So I'm not positive that picture is that you could tell from that angle that he's pointing it directly at Rittenhouse. It looks that way in the picture, but every picture is slightly misleading because of the moment that it's taken, and you can't tell which way his arm is moving and exactly which way he points. But honestly, it's irrelevant, okay? That right there is good enough, and the testimony is good enough, very likely for Rittenhouse to get off on that charge, okay? And I would say rightfully so, okay? But with a giant caveat that I'm gonna get to in a minute.
So what's the implication of that answer? Well, if someone's putting a loaded gun at your head, would you fire if you were in Kyle Rittenhouse's position? If your answer is yes, then Kyle is not guilty by means of self-defense. And if you say no, then Kyle has committed an attempted murder. Now, to start this case in chief, the defense put on several rebuttal witnesses, but the shock of the case came when they called Kyle Rittenhouse to the stand. Now, pro tip, if you're a lawyer representing a defendant in a criminal murder trial and you're winning the case, you don't need to put the defendant on the stand. I was shocked. I think most attorneys were shocked when this happened. See, there is no reason why Kyle should have been on that stand. I'm just going to give it to you cold, right? Literally, every witness the prosecution put up proved Kyle's self-defense claim. So there was no reason for him to say anything. For those of you who don't live in the United States, the criminal defendant here in America has a constitutional right not to testify. And the risk to testifying is great because if that defendant goes on the stand and admits to any other crimes, they could also be charged with those crimes. So Kyle took the stand, he gave his side of the story, he broke down as you saw, and now he's subject to cross-examination, which is the real test of whether he is going to be convicted or not. So the state's attorney started with suggesting that Kyle's silence was indicative of his guilt. Now, the state is generally not allowed to comment on the defendant's post-arrest silence. This would be a violation of Kyle's Fifth Amendment right against self-incrimination, and the state prosecutor should have known it. So there was an objection that was sustained, and then the state prosecutor did it again. Now, this caused the judge to be annoyed at this obvious violation of Kyle's constitutional rights. Now, after that debacle, the prosecutor attempted to get some propensity evidence in that the judge had previously ruled would likely be inadmissible without asking the court's permission. So that was enough for this judge. He had seen enough, he had heard enough, and he needed to tell the prosecutor to stop it.
Attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an experienced attorney, and he knows better.
Mr. Finger?
First of all, Your Honor, this was the subject of a motion. I'm well aware of that, and the court left the door open.
For me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move
that
to
was
reconsider.
their motion.
We have not filed any
me.
motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
So after that admonishment, the cross-examination continued. Kyle held up under pressure and, got off the stand without doing any real damage. Or we thought he didn't do any real damage. But we'll see later. He actually saved the prosecution's case, and we'll get into it in a second. So the defense put in a couple more witnesses, and then they rested their case. So now that the defense and the prosecution had rested, the prosecutor wanted to add some additional charges where they wanted the jury to consider. They argued for that for a while, but at the end of the day, the charges are now going to the jury. But something very important happened during this time frame, on the last day of the trial, literally the fourth quarter. See, the prosecution's case, I believe, has been destroyed. It's been lost. There's no way that they could win based on the evidence they've presented, based on the original theory of the case that Kyle was just some random lone gunman going around killing people. So that theory of the case had to change, and it changed dramatically in the last day. The prosecution is going to get a jury instruction that allows them to argue that Kyle provoked the attack against Rosenbaum. And it's extremely, extremely important that you understand this point, because this really exposes Kyle to a great amount of criminal liability. Now, the prosecution wants to use this picture that you see on the screen to show that Kyle pointed a gun at a man named Zeminski. And by pointing this gun at Zeminski, he provoked Rosenbaum. Here's a prosecutor explaining it.
As it relates to 815, which is the provocation instruction, is the state saying the presence of Mr. Rittenhouse there is in and of itself provocation?
No, we are saying that in the incident of Mr. Rosenbaum, he provoked it by raising his rifle and pointing it at individuals. So that is why Mr. Rosenbaum then gave chase to him. The defendant. The defendant then had a duty to retreat. He retreated. Instead of giving notice of his withdrawal from the fight, he turned and pointed his gun again at Mr. Rosenbaum, an unarmed civilian, which he admitted he knew he was unarmed, and that continued. So, no, the provocation is not his mere presence. It's not his mere presence with a gun. We will argue that the video evidence, contrary to the defendant's testimony, shows that he raised his weapon at individuals, and that is what provoked the attack.
So we can all understand it to be on the same page. The new theory of the case is Kyle provoked Rosenbaum by pointing the gun at Zeminski. If that's true, and Rosenbaum was legally provoked, then Kyle would not have a claim to self-defense against Rosenbaum and would be guilty of murder. But there's a collateral piece to it that I think some people are missing. If Kyle then murdered Rosenbaum, then he would not be justified in shooting Huber or Grosskreutz because they were trying to arrest or stop Kyle, who would have just committed a homicide or a murder. Now, all this depends on if Kyle pointed the gun at not Rosenbaum, but Zeminski. And by pointing the gun at Zeminski, he provoked Rosenbaum, and then you have this domino effect. I know, insane, but that's where we are. Now, why is this so important? Well, think about it. Under the original theory of the case, they had Kyle as being an active shooter. So they essentially were trying to prove that in each individual case, Kyle shot these people individually. But they also would have to prove that Kyle was not justified in each individual shooting, right? They had to prove that Kyle didn't act with self-defense in each one. But now with this provocation prosecution, what that allows the prosecutor to do is say, well, listen, he provoked all the shootings, everything, with this by pointing the gun at Zeminski. He provoked Rosenbaum, and that caused a chain of events that makes all the subsequent shootings non-justified, right? Self-defense wouldn't be available to Kyle because he provoked the series of events. It's a nice tactic, and I'm not sure if they're going to be able to sell it to the jury, but we're going to see. Most attorneys are now concerned because if you find that Kyle provoked the whole incident, then that really damages his claims of self-defense. Could a reasonable jury buy it? Yeah, I think they could. So on Monday, the jury starts its deliberations, and we'll see what happens. This is your Kyle Rittenhouse trial update. Let me know what you think. Let me know if you think Kyle is guilty. Let me know if you think he's innocent. Let me know how you think the prosecution's provocation theory now of the case is going to work, or whether it's going to change. Did it change your mind? Are you now convinced that Kyle may be guilty if this provocation thing is true? Let me know in the comment section. Hopefully you like this quick update on the Kyle Rittenhouse case, week 2, and we'll see you next week. We are going to find out if Kyle Rittenhouse is found guilty of murder or if he's going to be found not guilty by means of self-defense. My name is Nate the Lawyer. I'm out of here. Peace.